Court is on the record in City of Conneaut versus Todd Estes II, case number 25 CRB 131. In this case, Mr. Estes pled not guilty to one count of domestic violence, a first-degree misdemeanor, on May 12, 2025. We conducted a first pretrial conference on May 21st, and today we're scheduled for a second pretrial conference in that case. More immediate is the court is also taking up State of Ohio versus Todd Estes II, case numbers 25 CRA 148 and 25 CRB 149. In these cases, Mr. Estes pled not guilty to one count of burglary, a second-degree felony in the CRA case, and one count of domestic violence, a fourth-degree misdemeanor in the CRB case. These cases are set for a preliminary hearing and pretrial conference today. The court will note for the record that other charges against Mr. Estes of burglary and theft, 25 CRB 150, 25 CRA 150, and 25 CRB 151 were scheduled today for a preliminary hearing and pretrial conference. The law director did file a motion to continue the preliminary hearing and a pretrial conference in those cases as a result of a witness's unavailability. The court did grant that continuance and rescheduled those two cases for June 2nd. That would be next Monday at 9:00 a.m. Present in the courtroom is Mr. Estes. He is currently incarcerated in the Conneaut City Jail. On the new cases filed against him, he was brought up to appear personally for this hearing. His attorney, Mafid Sayed, is sitting next to Mr. Estes, along with Law Director John Lewis and Patrolman Charles Burlingham sitting at table with Mr. Lewis. I understand that we're running a preliminary hearing, Mr. Lewis.
It will appear that way, Ron.
Yes, okay. Sir. Go ahead and call your first. Any argument, counsel?
No, yeah.
Wait, this time, yeah.
Okay, call your first witness, Mr. Lewis.
Your Honor, the State of Ohio is called Dakota Mullen.
Mullen, you can step forward, please. Before you're seated, ma'am, can you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may be seated. Ms. Mullen, can you ensure that you speak loudly and clearly so that we can make a proper record of this proceeding, okay?
Okay.
Okay, you may begin, Mr. Lewis.
Thank you, Your Honor. Ms. Mullen, would you please state your full name and spell your name for the record?
I'm sorry. I did lose my voice. Dakota Mullen, DAKOTA MULLEN.
And ma'am, where do you reside?
State Street.
Is that here in Conneaut?
Yes, sir.
Okay. Are you familiar with the defendant, Todd Estes?
Yes.
And how are you familiar with him?
He's my boyfriend.
I want to direct your attention to the 16th of May, 2025. First of all, are you involved in a domestic violence case with Mr. Estes?
Yes.
Or you're the victim and he is the defendant?
Yes.
Yes?
Yes. I'm sorry.
And is there a no contact order to your knowledge in that case?
Yes.
Yes?
Yes.
Okay. I want to direct your attention to May 16th of 2025. Did you encounter Mr. Estes that day?
Yes. Yes.
Yes? How did you encounter him that day?
He was at my window.
I can't hear you.
But I'm sorry. He was at my window. That was the day that the burger I can't say the word. When he came to my window,
He came to your window?
oh, I don't know what date that was. I don't remember what happened on that date. Is this for the like burglary charge? I'm
Yeah.
sorry, I can't say the word. Yes, he came to my window. Yeah.
Came to your window?
Yes,
Which window?
the back window.
Of your house?
Yes.
What happened next?
We talked through the window, and he came in, but it was no aggression, nothing like that. I gave him water, and then was walking him out, and that's when I sprayed him.
Your Honor, I can't hear what you said.
I'm sorry.
You have
I
to
can't.
speak up louder, man.
I lost my voice. He came to my window, and I gave him water after I had him give me all the stuff that he had of mine. And when I was escorting him out, that's when I sprayed him.
What, you sprayed him?
I maced him, yes.
Okay. Well, why did you mace him?
I used to be a CO. I always have mace on me. I used to be a CO. I always have mace on me, especially when they're with what happened. Just in case anything were to happen, I could protect myself.
Oh, just so I understand what you're saying. You're saying you allowed him to come into your house?
Yes.
You allowed him to?
The window was unlocked, yes. But
Did you tell Conneaut Police Department on
he
May 16th that he climbed up the side of your house, came in a second story window?
yes,
Okay, so which is true?
he climbed up to the second story and he came in my window, but I was there with water after I talked to him and made sure he was there.
Did you tell the Conneaut Police Department that he lunged at you?
Yes, he did.
Okay, is that what you told the Conneaut Police Department that day?
Yes, and that is what happened.
And then you maced him? Is that what?
Yes, that's when I was escorting him out. And I don't know if it was aggressive or not, but regardless, I maced him because
Let me ask you this: what
fight
happened
or
after
flight.
you maced him?
He left, and I called the police.
Did he have permission to be in your home?
Legally, no. And technically, no.
Did he have permission to be in your home? Yes or no?
No.
And you are aware that there is a no contact provision of his bond in the domestic violence case. Is that correct?
Yes.
Okay. So just so we're clear here, your testimony is that on May 16th of this year, Mr. Estes climbed up the side of your house. Is that
Yes.
correct?
Yes.
And he came in through a second story window.
Yes.
Okay. Was he permitted to come into your house that day?
Legally, no.
Okay. And he lunged at you?
As I was escorting him out, yes.
So yes.
Yes.
Okay. And then you maced him.
Yes.
And then what happened after that?
He left. He ran, and I called the police.
And you called the police?
Yes.
Okay. And did the police come?
Yes.
Do you remember who you spoke to that evening? Police officer?
Officer Dan and was he right? Him.
Okay. And did you give a written statement to the police officers?
I just agreed with what questions. I didn't write anything.
Okay.
But
they took a statement from you.
Yes.
And you described to them what you just basically described to us, correct? You indicated that Mr. Estes lunged at you, is that correct?
Yes.
And then you maced him.
Yes.
Okay. And then after you maced him, he fled, is that correct?
Yes.
I have no further questions at this time, Your Honor. Thank you.
Thank you, Mr. Sayed.
Thank you, Your Honor. Good afternoon, Dakota.
Good afternoon. Sorry, it's hard seeing them like that.
First, how did you get here today?
I was escorted here.
By who?
An officer, they suspended my license.
So the police department came and got you here.
Yes,
How long have you known Todd?
a long time.
Roughly how many years?
I met him when I was 17.
How old are you now?
I'm 24.
So 7 years.
Yeah, oh my god, yeah.
How long have you guys been dating?
Since right after Christmas.
This past Christmas.
Yeah.
So 5 months, 6 months now, almost. You guys are still dating?
Yeah, hold on. You don't speak. Go ahead. Answer his question. Are you still dating?
Yes.
You two are still together.
As far as I'm aware, yes.
Was your relationship always rocky from the start?
No.
It was good in the beginning?
Yes, sir.
So let's talk about first. The prosecutor brought up the fact that there's an ongoing domestic violence case with Todd. Is that right?
Yes.
Who else has an ongoing domestic violence case against you?
Objection.
Yeah. Sustained.
Let's talk about the incident that happened on May 16th, 2025.
Yes.
Okay. You said Todd climbed up the second story.
Yes.
How did he climb up the second story?
A ladder.
Okay. He brought a ladder with him?
No, my backyard is filled with junk. It's not that hard to get in any window in the house.
Did you know he was coming?
No.
Did you leave the door? Did you leave the window open?
No, I opened it.
You opened it for him?
Yes.
You let him in?
After seeing his feet bleeding, him needing water, and he hasn't eaten in days, or I haven't heard from him in days. Yeah.
So you let him in?
I unlocked the window after getting my belongings, which included stuff from my car, yes. To give him water and food and clothes that he wanted, that's what he came there for. And I went to go escort him out, and that's...
Okay. So, I'm sorry, I didn't hear. I know you lost your voice.
I'm sorry.
You said he came with your belongings and then he left with his belongings?
He didn't get the chance to get his belongings because I felt safer if he was out back.
Okay.
Well, I grabbed his bag that I already had packed. But we were... I honestly don't remember if we were arguing or what, but I wanted him outside, and I kind of liked that after that.
But you allowed Mr. Esses to come inside?
Yes. Legally, he was not allowed there, but yes, I did let him in.
So that's what you meant earlier when you said legally, no.
Yes.
But you let him inside?
Yes.
There was no forced entry?
No.
Mr. Esses didn't break the glass to get in? He didn't use a weapon?
He didn't even try to break in a door. He knocked on the window.
Okay.
He was not aggressive at all. He needed help.
He wasn't stealthy?
But
he wasn't trying to sneak in and catch him by surprise. Okay? He didn't use a deceitful manner to come inside your house, like pretending to be someone outside.
No, he said, "Please let me get my things. I want to go. Let me get some water. I'm hot." I'm his only home out here. And after I retrieved the things he took from my car, and I felt safe enough to grab his bag, give him water, food, and shoes, and send him on his way, I opened the window.
The shoes you gave him, were they his?
He did not end up getting shoes.
Okay.
When he came in, I said, "Can we go downstairs so I feel safe when you're outside? I'll grab everything I already have packed and whatnot." And he didn't end up leaving with any of his belongings. But the shoes would have been his, yeah.
The shoes would have... Okay, so can we back up a little bit, please? So, Mr. Estes was living with you.
Yes.
How long were you guys living together?
He was since January, early January, first week.
So the beginning of your relationship, you guys were already living together?
Practically, yeah.
Okay. So his stuff was there.
Everything of his is there.
Everything of his was there.
Yes.
So that night on May 16th, and when you let him in, he was just grabbing his stuff. He wanted to grab his stuff.
Yes.
Okay. So he wasn't trying to take anyone else's property. Who else lives with you in this home?
Me, my mother,
Mm-hmm.
and my stepdad.
So total 5 people.
4.
Oh, okay. I'm sorry. 4 people.
Yeah.
So 4 people. So when Todd came that night, okay, he didn't give you the impression he was trying to take.
It was still daytime.
Oh, the daytime. Okay. He didn't give you the impression he was trying to take anyone else's belongings.
No, he was not aggressive. He was just begging for his things and water. And I seen how roughed up his feet were.
Mm-hmm.
He looked a mess and he needed help. And I'm the only person he knows out here that would be willing to help him. And I don't care who it is. If they look like they're dying, I'm going to help them.
Do you still love Todd?
Yes.
You love him right now?
Yeah.
You care for him?
Yes.
That's why you let him in that night?
Yes.
Yeah, I had no further questions.
Thank you. Any redirect?
Yes, Your Honor, thank you. Ms. Mullen, why didn't you just let Mr. Estes in the front door?
I didn't hear him knocking.
He knocked on the front door?
That's what he said. I've been knocking for a minute out. I don't know how long, but I did not hear it.
Why would someone who was welcome in your home put a ladder up against your house and climb up the side of the house and enter through a second-story window?
Because the doors were locked and I was not answering because I had music playing, so I did not hear him knocking.
So your testimony today is that you let him into the house. Is that correct?
Yes.
When you just testified, when I was questioning you, that he did not have permission to be in your house.
Legally, no. He did not have permission to be in the house. If it was a different circumstance...
So if everything was so nice and lovey-dovey on May 16th, 2025, why did you mace him? And why did you call the cops?
I maced him because I was trained as a CO that if anybody lunges at me, I protect myself. And there was... And he needs psychiatric help. I don't know who or what state of mind he was in when he lunged at me, but regardless of who it is, if I feel that I could be in danger, I'm going to protect myself. But he seemed fine upstairs. I don't know why he lunged.
So if he had permission to be in your house in this moment, why'd you call the cops?
I called the cops because he lunged at me.
He lunged at you?
Yes.
Okay. You didn't tell the cops that he came up the side of your house on a ladder, came in through a window. You didn't tell the officers any of that?
No, I did.
Okay.
That's exactly what happened,
You just got
too.
done testifying, Mr. Syed said you let him in the house.
Yes, I said he came into the window. He did not break in the window.
Oh, okay. So you let him in the house?
Through the window.
Second-story window.
That he climbed up, yes. But if it was different circumstances, if he was aggressive at the window, if he had intentions of malicious intent, I would not have let him in.
You didn't hear him knocking on the front door, but you heard him knocking on a second-story window. Is that your testimony?
Because it's right by my room. It's right by my room, and he was knocking at the back door, I guess, because my stepdad screws the front door shut, so you can't get in there.
Connor, I'm going to approach the witness, if I may, and offer her, this is going to be State's Exhibit A. This is a written statement that she provided to law enforcement that night because her testimony is way off base from what the circumstance says.
Objection, Your Honor.
Good.
She stated that the police officers wrote the statement for her. She never actually wrote a statement.
Did she testify that?
I believe she did earlier.
Yes.
That's why I brought it up.
So there's a statement that you have that she signed. Does this have her signature?
There appears to be two different handwritings on here, Your Honor. I would assume one of those handwritings belongs to Miss Mullen.
Okay. So are you trying to treat this witness as hostile?
I'm sorry, Your Honor.
Are you trying to treat this witness, your witness, as hostile right
Yes,
now?
Your Honor. She's given testimony here today that is not at all consistent with what
Let
she
me
said
see your
to law
statement
enforcement.
then. Let me see your statement. Here, we'll get it. Go ahead. Allowing the prosecution to treat Ms. Mullen as a hostile witness.
What do you have there in your hands, Ms. Mullen?
The statement that was written on the 16th.
Okay, is your handwriting appear on that document?
Yeah.
Okay. What part of that is your handwriting?
The top part.
The first paragraph?
Yes.
Okay. Could you read that for the court?
Todd Estes climbed up the side of my house. He came in my window. As I was walking him out, he lunged at me and I maced him and he ran out the back door.
Anything in there about you let him in the house?
No, I just said he came in the window.
Could you read the rest of the written statement?
Yes.
Please?
I'm sorry, I'm having a hard time reading it. Did Mr. Estes have permission to be in the house? No. Which I meant legally. Is Mr. Estes allowed to have contact with you? No contact order? No. Do you want to pursue charges against him? No. Did Mr. Estes... I'm sorry. You can't. I can't read the.
Don't help the witness.
I'm sorry.
No, go ahead.
I can't read it.
That's fine. That's fine. So anything in that written statement about that you let Mr. Estes into your house?
No.
Anything in there about giving him his belongings?
No.
And in that statement, you indicated that he did not have permission to be in your home. Is that correct?
Yes, because legally he could not.
Sorry?
Yes, because he legally could not be there.
Okay. And you maced him?
Yes.
And called cops?
Yes. I've seen a switch in his eyes, and he needs help. He needs medication. So I don't know what he changed to, but whether it was malicious or not, I'm not taking chances. I maced him, yes.
So just to be clear, you did not tell Officer Burlingham or any other officer that you let him in your house. Is that true?
I can't recall, but on here is no.
Okay. So you didn't tell him that?
No.
Okay. What did you tell him?
I told him that he came in my window.
Okay.
And
that he didn't have permission to be there, correct?
Legally, no.
Thank you. No further questions at this time, Your Honor.
Thank you. Yeah, I'll just allow some recross on what Mr. Lewis just asked. Any recross?
Thank you, Your Honor. Dakota, I understand on the witness statement it says you never mentioned anything about not letting him in.
Mm-hmm.
Your window was open, correct? Or you opened
I
it?
opened it.
You opened it for Todd.
Yes.
Okay. No further questions, Your Honor.
Thank you. You're excused, Ms. Mullen. You're not going anywhere because we have a traffic case we have to address with you after this is over. So you can go to the back of the courtroom.
I'll leave it here. I'm sorry.
Okay, anything further, Mr. Lewis?
Yes, Your Honor. State of Ohio Fellow Officer Charles Burlingham.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may be seated. Thank you. You may proceed.
Thank you, Your Honor. Officer Burlingham, please state your full name, spell your name for the record.
Charles Burlingham, Burlingham.
And you're employed by the County Police Department, correct?
Yes, sir.
How long have you been so employed?
35 years.
And you are a certified peace officer in the state of Ohio, is that correct?
Yes, sir.
I want to draw your attention to May 16th, 2025. Were you on duty that day?
Yes, I was.
And do you recall what shift that might have been?
Night shift, 7 p.m. to 7 a.m.
Okay. And did you respond to a call from Dakota Mullen that evening?
Yes.
And could you describe the nature of that call?
We got a call that Mr. Estes had was at the house and he wasn't supposed to be.
Okay. And what, if anything, did you do in response to the call?
Well, I drove to the scene and I met with Miss Mullins on the front yard.
Okay. What was her demeanor like?
She was upset, crying.
Okay. Did she say any, strike that? Did she give a written statement? Did she give you a written statement?
Yes.
Okay. Your Honor, if I may show the witness the exhibit. Thank you. This has been marked as State's Exhibit A. Do you recognize that?
Yes, sir.
What is that?
That is the statement I took from Dakota that night.
Is her handwriting, first of all, did you write that entire statement yourself?
No, I did not.
Okay, so she wrote part of that, is that correct?
That is correct.
Okay. And then you asked her some follow-up questions. Is that a fair statement?
That is yes.
Okay. And does that appear to be a true and accurate copy of the written statement from that night?
Yes.
Other than taking a statement from Miss Mullen, what, if anything else, did you do as far as investigating the call?
Personally, yes. She told me that he could. I asked her if he could still be inside the house. She said he could. So she went inside and she locked the dogs up. And Patrolman Patriarch and I went inside and checked the house.
Did you see any signs of a ladder, as Miss Mullen just described, or any sign of forced entry anywhere or anything like that?
Well, the upstairs bedroom, or not bedroom, hallway window was open, and we checked up there. And when we went outside afterwards, because she said he exited out the back door, we went outside and there was a ladder up against the back of the house.
Did Miss Mullen say anything to you about letting him into the house?
No,
Your impression was that he entered without permission.
that's correct.
Okay. Any evidence of mace in
There was definitely mace had been sprayed inside the house because it was irritating their throats and making us cough.
okay. You could smell the mace.
Yes.
Did it affect you?
Yes.
Okay. And you had another officer with you, is that correct?
Yeah. Patrolman Patriarchal.
Okay. And so you noticed, you could tell that mace, and based on your training and experience, you could tell that mace had been sprayed.
Yes.
Okay. Anything further, Officer Burlingham, any further investigation on your part?
You know, I went there a couple of times to talk to her again because there was a camera on the back on that night, on the video camera on the house. And I asked her if if that worked or recorded anything. And she said, I think her mother or father only had access to it. And I stopped there 2 other times to get in touch with her and nobody answered the door.
And just so we're clear, who was the primary caller with regard to this case?
Dakota.
Okay. Thank you. No further questions, John.
Thank you. Cross examination.
Thank you, Your Honor. Good afternoon, officer.
Good afternoon.
How are you?
Good.
How long have you been? How long have you been in law enforcement?
35 years.
Long time.
Mm-hmm.
Not even that old. Um, so let's go back to May 16th, 2025. Okay, you respond to a call from Dakota.
Correct.
Correct. What time roughly?
It was a little bit after 7.
Was it still daylight out?
Yes.
So you could see. You could see.
Mhm.
Okay. Uh, you were allowed inside the house.
Correct.
You said Dakota was crying.
Mhm.
She was upset.
Yes.
Officer Burnham, do you know why we're here today? What Mr. Estes is charged with?
Yes.
Which is
Burglary.
okay. He's not charged with lunging at someone for this particular hearing, correct?
Yes.
As far as you know.
Correct.
So you went inside the house. You spoke with Dakota. How long did that conversation take place?
I don't know. It was like 5 minutes, but it was outside originally.
Outside. And then she let you into the house.
Correct.
And you investigated the home.
We checked for Mr. Estes. Yes.
Mr. Estes wasn't there at that time, correct?
Correct.
Then you went check for any signs of forced entry.
Well, we were upstairs, and that's when we saw the window that she said he came in.
Okay. Did you look at the window?
I don't think the window was even there.
I'm sorry?
The window wasn't even there.
There was no window? But you just mentioned you went upstairs and you saw there an open window. Did you not?
Well, open frame.
Okay, so there's a window opening, but there's like no glass or anything?
Right.
Okay, so the window couldn't be closed if it wanted to.
I have no idea.
You don't remember?
I have no idea if it can be closed. I mean,
So
They-
was the window open?
they can put something in there, close it. I have no idea what they do to.
So that window right there, that's closed, correct?
Correct.
Okay. In Dakota Mullen's residence, was it wide open?
Yes.
Okay. Were there signs of broken glass?
No.
Were there signs of forced entry?
No.
Okay. And then after you concluded that there was no signs of forced entry, what happened? Did you go out looking for Todd?
Correct. We went back downstairs and we went out the back.
Todd was not there.
He was not there.
When you went out the back, was there a lot of junk in the back?
There were some.
Some junk? Just okay. No further questions, Your Honor.
Redirect.
No, sir. Thank you.
Thank you, officer. You're excused. Thank you. Any further evidence, Mr. Lewis?
No further evidence, John.
Okay. Would you like to offer this exhibit or?
Yes, Your Honor.
So Exhibit A, the statement of Dakota Mullen. Mr. Sayed, any objection?
No objection at this time, Your Honor.
Okay, plaintiff's Exhibit A will be admitted without objection. Does the plaintiff rest?
Yes, sir. Thank
Okay.
you.
Okay, Mr. Sayed, any evidence?
Your Honor, at this time the defense rests.
Okay. Argument, Mr. Lewis.
Thank you, Your Honor. Clearly, Ms. Mullen is a little bit confused, maybe not sure what she wanted to do with this case. She indicated in the written statement there, State's Exhibit A, that she didn't want to press charges. That's fine, but if you don't want to press charges, why do you call the police to your home? Why do you mace the individual that you told officers did not have permission to come into your house and enter through a second-story window? Why would you do these things? She clearly, in her mind, testified that her and Mr. Estes are still in a relationship. She has a bias of trying to protect Mr. Estes from this prosecution. But it's clear, Your Honor, based on her testimony, her written statement, Officer Burlingham's testimony about smelling mace in the house, that the version of events that she gave to officers in that written statement, State's Exhibit A, is what is true. Why else would she have called law enforcement on that night if it were not true? There's evidence of a ladder. Officer Burlingham saw the ladder that shows that Mr. Estes entered the home through a second-story window. knocked on a window that was apparently non-existent, and came into the home. Your Honor, the complaint indicates that on or about May 16th, City of Conneaut, Mr. Estes did knowingly, did by force, stealth, or deception rather, trespass in an occupied structure, namely 487 State Street, when another person other than an accomplice was present, namely Dakota Mullins, with purpose to commit in the structure any criminal offense to a domestic violence. Contrary to Mr. Syed's argument, he is charged with lunging at her. That is where the domestic violence count comes in under 2919.25C. Your Honor, the victim, alleged victim's own statement makes it clear that the state of Ohio has shown probable cause that Mr. Estes committed a burglary on May 16th in her home at 487 State Street. And the state of Ohio is requesting that the case be bound over to the grand jury for their consideration, and the misdemeanor case would also accompany that. It's clear that Ms. Estes was telling partial truths when she was here on the stand, and that her written statement is in fact a clearer recitation of what actually happened on May 16th. Thank you, Your Honor.
Thank you, Mr. Sage.
Your Honor, this case is about whether Todd Estes and we understand that Todd and Dakota have complicated history. I know this. The law director knows this. This court knows this. Okay. We're not here to talk about the macing or the lynching. We're here to see if he committed burglary and if there's probable cause presented by that. There isn't any today. Mr. Lewis wants to paint this picture that Dakota's been lying. She didn't lie. The witness statement is true to what she's been testifying today. The window was open. He came in through the window. She didn't go into detail. Obviously, it's like a sheet of paper, which to the court's attention I have not seen. But she stated she let him in. She let him have water. She stated there was no force, there was no stealth, there was no deception. We've heard from Officer Birmingham. He investigated the scene. He said there was no force detected. We know that there was a ladder there because Dakota said that there was that her stepdad keeps junk in the back and there was ladders back there. In her own words, I allowed him to come in. That's not trespass. And if there's no trespass, there's no burglary. So at this time, Your Honor, there's not enough probable cause here for this to get bound over. He doesn't meet the requirements of burglary. There's no force, there's no stealth, and there's no deception. Dakota welcomed him in as if he was a guest. She took care of him. She even mentioned, I wanted him to grab his belongings because his belongings were there. They lived together since January. He was returning her belongings, I believe. So for the evidence presented today, including her testimony and the testimony of Officer Birmingham that there was no force, this does not meet the statutory requirements of Revised Code 2911.12. Thank you, Your Honor.
Thank you. Any argument responding, Mr. Lewis?
Well, contrary to what Mr. Syed is saying, there doesn't need to be force. There can be stealth. I don't think it's. I think that the circumstantial evidence, aside from Ms. Mullins' testimony, shows what happened here, Your Honor. She called the cops. She called law enforcement. She called 911. That's why they responded. She also maced Mr. Estes, and the officer Burlingham testified they could still smell the mace in the house. So you've got a ladder leaning up against the window. You've got an individual who was maced, and you've got a young lady who called the police and initially told the police that he entered through a second-story window and that he had no permission to be in the house. And that's what her written statement says. We don't have to show forced entry here, Your Honor. It could be by force, stealth, or deception. Thank you, Your Honor.
Thank you. So one thing I wanted to address is 25 CRB 131. This is the original domestic violence case. He was charged. He pled not guilty. Domestic. I ordered as conditions of his bond that he have no contact with Dakota Mullen and remain off the premises at 47 State Street. He entered that plea on May 12th. We conducted a pretrial conference on May 21st, at which time the law director orally withdrew its motion to revoke bond that was filed on May 19th. So I just want to make sure that was orally withdrawn.
It was, Your Honor. At the hearing, Ms. Mullen did not appear for that hearing of the court, which is what we call it, and that's I had no choice but to withdraw my motion at that time.
Okay.
Thank you.
Okay. In looking at Ms. Mullen's written statement, Todd SD climbed up the side of my house, came in the window, and then something walking out, he lunged at me. I maced him. He ran off the back door. In her written statement, and even in the questions that follow, it doesn't mention about how he entered the second story of the home, whether she let him in or not. I'm sure in calling the police, she probably led the police. That's why they did the investigation, to believe that he probably was there. But at least with respect to consistency of testimony here between her written statement and her testimony today, there doesn't seem to be inconsistency about how he entered, whether she let him in or whether she knew about it. But her testimony today is that she allowed him to enter to get his clothes. So yeah, I did order him to stay out in the 25 CRB 131 case, but that cannot be used as a basis for trespass. I'll deal with that here shortly. So not only did Mr. Estes not trespass, but there's no evidence that he entered this property with purpose to commit domestic violence. There's no evidence whatsoever. That was his reason, based on Ms. Mullen, was to get clothes and to get water, and something happened as she was walking him out. I do find, based on the evidence presented after preliminary hearing today, that probable cause has not been established for the offense of burglary in case number 25 CRA 148, and this case bond will be discharged, and this case will be dismissed. We will schedule 25 CRB 149, that's the domestic violence case, for another pretrial conference on the same date as the other cases, for June 2nd, 2025 at 9 a.m. I am revoking the defendant's bond based on the testimony, whether there's a pending motion or not. In 25 CRB 131, the court's own motion, the defendant clearly violated the court's bond in 25 CRB 131 when I ordered him to have no contact with Dakota Mullen and to remain off the premises at 147 State Street in Conneaut. I did allow him to retrieve his personal belongings at that residence with a police escort only. And that didn't happen. And I guess people don't care what I ordered and as conditions of his bond, so I'm revoking his bond in that case. And he will be held without bond in that case. And this case will as well be set for another pretrial conference for June 2nd at 9 a.m. Okay. I think I've addressed everything. Is there anything further, Mr. Lewis?
No, Your Honor.
Mr. Syed?
No, Your Honor, not this time. Thank you.
Okay. Mr. Mullen or Mr. Estes will be taken back down to jail, where he'll be held until June 2nd. Ms. Mullen, step forward, please.
I'm see you Monday.
See you Saturday. Yeah, we'll see you Saturday. Oh yes, we'll see you Saturday. Thank you, sir. See you later.
Good.
May I? Think
Officer, if you need to go somewhere else, you can. You can stick around. It's up to you.
I gave her right here. I'll probably give her.
Oh, that's right.
Unless
Okay.
she's got another one.
Sorry about that. I didn't know that.
Do you? Somebody in the ticket?
I don't.
Oh, okay. You don't. Okay.
Sorry.
Okay, the court is on the record in the City of Conneaut versus Dakota Mullen, 25 TRD 380. Ms. Mullen failed to appear for an initial appearance hearing on a traffic citation that was issued on May 11th, 2025. She failed to appear, and as a result of the failure to appear, the court went ahead and started the process of issuing a license forfeiture. Ms. Mullen just testified in another case, and she is present. Ms. Mullen, a traffic citation was issued against you on May 11th, 2025. It appears to have your signature on the side of it. Did you receive a copy of that traffic ticket?
Oh, yes, sir, I did.
Okay, why were you not here at the last hearing?
I actually was just talking to the officer about it. I thought it was for next month on the 11th.
Okay,
And I guess it was written on the 11th, so I just did not read the ticket correctly.
No, you didn't. Okay, I'm going to read you your rights, so please pay attention to the rights I'm about to read to you. You do have a right to be informed of and understand the nature and the elements of the charge filed against you. You also have a right to know the potential penalties that could be imposed. You're charged with one count of failure to illuminate a rear license plate. It is a minor misdemeanor. It's punishable by a maximum $150 fine and court costs. You understand that?
Yes.
You have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a trial to the court. At trial, you have a right to cross-examine witnesses and to confront evidence presented against you. You have a right to use the court process to secure the attendance of any witness who you would want to testify on your behalf. At trial, you have a right to be proven guilty beyond a reasonable doubt and a right not to testify. You also have a right to have an attorney represent you in this proceeding. You are not entitled to court-appointed counsel. This is not a jailable offense, but you can retain the services of your own attorney at your own expense for representation and counsel. You also have a right to a continuance of this initial appearance hearing in order to retain your own attorney and to seek the advice of your own counsel. If you are convicted of this offense or any related offense, you have a right to appeal the conviction or sentence. That must be done within 30 days of the conviction. If you plead not guilty to this charge today, I will set your case for further proceedings after today, and I will set a bond. A bond is set by the court to ensure your appearance at all future proceedings, and today you have the right to a reasonable bond. If you are not a citizen of the United States, you're hereby advised that conviction of the offense to which you could be pleading guilty or no contest may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Ms. Mullen, you have three plea options with respect to this charge. You can either plead guilty, not guilty, or no contest. If you plead guilty, that is a complete admission by you to the offense charged. If you plead guilty, the court will find you guilty, and then I will impose sentence. Second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the offense charged. And as I said earlier, if you plead not guilty, I will set your case for further proceedings after today, and I will set a bond. The third option is you can plead no contest. If you plead no contest, that is not an admission of your guilt, but it is an admission by you of the truth of the facts alleged in the complaint filed against you. If you enter a plea of no contest, this court will find you guilty, and I will impose sentence without any evidence being presented against you. However, the plea of no contest cannot be used against you in any later civil or criminal proceedings. Ms. Mullen, do you have any questions regarding the rights or plea options I've just explained?
Yes, sir. I'm just truly. I'm not gonna be getting anybody to represent me.
You're what?
I'm not gonna be getting anybody to represent me or anything.
You're not entitled to court-appointed counsel.
I'm And
Do you have any questions regarding the rights or plea options I've just explained?
No. I have no
Okay,
questions.
so how would you wish to plead to this charge?
Guilty.
You understand by pleading guilty that you're waiving all of those trial rights I just explained to you.
I personally don't know what the best option is, but yes.
Okay.
Uh,
You understand what a trial is? We just experienced
Yes.
somewhat of a trial. By
Yeah.
pleading guilty to this charge, you would be waiving your right to a trial. Is that what you wish to do? You'd be waiving your right to be proven guilty in a courtroom of this offense.
yeah. I'm just gonna plead guilty.
I understand you're going to plead guilty, but I need to understand that you understand what rights you're waiving by
Yes,
pleading
I'm
guilty.
sorry.
Okay, by
understand.
pleading guilty to this charge, do you understand that you are waiving your right to a trial?
Yes, Your Honor.
You'd also be waiving your right to an attorney at your own expense. Do you understand that?
Yes, sir.
Court does find the defendant's plea of guilty to this charge, minor misdemeanor offense, to be knowing, voluntary, and intelligent. Court will accept the guilty plea, and I would therefore find him guilty of this charge. Ms. Mullen, do you have anything you would like to say before I impose the sentence?
My license was suspended. I just need to know how much to get reinstated in court fine cost.
We started the process of suspending your license because you failed to appear.
Is there?
But you can resolve that with the court. I don't know if you got a license suspension from anyone else, but
No.
okay.
I've,
Is there anything else you'd like to say before I impose sentence?
if you have no answers for fees or anything, then no, you know.
Okay, I'm imposing $150 fine plus court costs. Total fines and costs will be $302. How much time do you need to pay it in full?
Maybe like 2 months.
I'll give you until July 31st, 2025. We will set this case for a review hearing after July 31st. If you fail to appear for that review hearing and have failed to pay it in full by the deadline, I will issue a warrant for your arrest. If you have paid it in full by the deadline, we'll cancel the review hearing.
Okay.
Okay, do you have any questions for me?
So the starting process of my license being suspended.
You can talk to the clerk about
Okay.
getting that resolved.
No further questions.
Okay, thank you very much. You go to the first window, they'll take care of it.
Thank you.
So the afternoon, I had eight landlord-tenant cases that all went pretty smoothly. So
Good.
just a regular day, although it feels like Monday to me. Looks like the jail has them hooked up.
Just to confirm, I've got 4 on Heather Sproul, the trespasses, and then a CCW on Skylar Weird, right?
Yes. Hello, Miss Sproul. This is Judge Middleton. I'm doing some jail arraignments today. The magistrate is off, and Judge Pattison's off. And so I'm here. Heather, we've been chasing you for a few months now. Let's go through these. File 242194OM is a trespass in the city of Sturgis on December 11th, 2024. And you didn't show up several times. I thought I gave you a bus pass on one of these. Anyway, you didn't show up several times and we issued a bench warrant. That was December 11th of 24 was the date. The next one is 2231. That was December 17th, another trespass that you failed to appear on multiple dates. The next one was 25294OM, another trespass from February 14th of 2025. And another one, 253650M, another trespass. Finally, I just gave up and issued bench warrants on all 4 of these, and the bond was $450 or $250 per file. You also have that old file from 23 where you and some others stole that $8,000 from that man, his computer, and you still owe money on that. Now, somebody wrote me a note that said you've got other charges. Do you have other charges other than
No,
these?
only trespassing, no.
Just these trespass?
Yes, sir, yes. It's because I'm homeless and I don't have to live.
I understand, but you can't just keep blowing off the court dates. They give you a ticket, you don't show up. They give you another ticket, you don't show up. They give you another ticket, you don't show up. So we don't get anywhere. With us is Mr. Chief Keith Stickley, the Chief Public Defender. There's no other charges other than these?
Oh, it's not, I'm okay.
I didn't see any.
Not that I'm
How
aware
did
of.
you come? How did you come to get arrested last night, Miss Frau?
Where we were sleeping, they come to tell us to move. Or we're gonna get trespassed again.
So it was
And
another,
he read my name. He read my name. He didn't give me another ticket. He just told me we had to move.
where were you last night?
Next to Dunham's. In the woods.
In Sturgis?
Yeah. Dunham's and Farmer's Fleet, back so kind of like behind Arby's or whatever.
All right, well, at this point, I'm gonna show you're gonna plead not guilty on all these. Today is Wednesday. I don't have another pretrial day with the Sturgis City Attorneys until next Wednesday. So I'm gonna set these for pretrial for June 4 at 8:30. You also owe a bunch of money. As I said, you and Tim Weller and some others took that $8,000 from that man, which ruined his life. He ended up being homeless again. He had a good job and was doing okay, and you guys pulled a rug out from under him. So maybe by the time I see you, we can deal with that one too, and maybe I can erase some of the jail time for that one. But I'm gonna leave the bonds at $250. Every time I set a bond, every time I set a hearing, you don't show up. Between these 4 files, there are probably 15 times you were supposed to be in court and didn't come. Now, sometimes you didn't even know about it,
No, I
but
didn't.
sometimes you did. Every time you got a ticket, it had an appearance date on it. If I let you out, have you got anywhere to go?
I could go to my aunt's house. She lives on 21307 US 12. It's Bonnie Myers. Is my family.
Who was with you last night?
I was by myself.
So they just picked up you?
Yeah.
No, did anybody else get a ticket?
No, because I was the only one there. George Rosario, my boyfriend, was out getting the money, trying to get pop bottles.
Did you get another ticket last night?
No, sir.
All right. They probably figure what's the point. So I don't know. What the city attorney will do is probably resolve all of these, and you shouldn't be just incarcerated because you're homeless. It's a struggle. The people they're on other people's property. They're told not to be there. They come back. At least it's summer now, so you're not going to freeze to death. But my fear is if I let you out, you're just not going to show up again. And, plus you
If
got
I
that
have
other.
bus tickets, I can. If I get some bus tickets, I could. If I have bus tickets, I could.
All right, well, I'll give you bus tickets when I see you next, but this, I said, is a dozen or more times that you failed to appear. And because you're homeless, you don't have any money, so you haven't made any payments on that electronic funds theft that you pled to in 2023. So bonds all are gonna be $250 a piece. You're gonna get 3 meals a day and a shower and be safe until I see you next. Looks like you dyed your hair. Is that
Yeah,
pink?
no, it's red.
Red? Okay. All right. I'll see you next Wednesday morning. Maybe we can resolve everything you got. But the bonds are $250 a piece.
There ain't nobody can do that.
No, you're good to go. It's not cold. It's not particularly warm. It's gonna rain tonight. But I want to know that you're safe and warm and you're gonna show up. So I'm leaving the bonds as set. Like I said, finally at the end, I just gave up and set a bench warrant in each case. And then I figured sooner or later but these bench warrants have been out since February or thereabouts. Yes, all right, you're good to go. I'll see you next Wednesday. I don't know what else to do with her.
Oh,
There
did you
was
hang up on the
another,
jail, Judge?
what?
Did you hang up on the
No, I
jail?
put him in the waiting room
Oh.
while she leaves. Another man who had been homeless and got a job and saved $8,000 and got an apartment and he let them move in and they just took over and took all of his money and he ended up homeless again. In fact, he may have died. It just completely unraveled his life. Good morning, sir, or good afternoon, sir. Are you Skylar Wired?
Yes, sir.
I'm Judge Middleton. Also here with me is Mr. Keith Stickley. Join us in a minute. He's the chief public defender. You got arrested last night on charge of carrying a concealed weapon. Prosecutors filed a formal complaint by Chief Assistant Josh Robert. They allege that you did carry a pistol, concealed or otherwise, in your automobile, a Ford F-250 big truck. That's a felony. It's punishable by up to 5 years imprisonment and a $2,500 fine. You and another gentleman were at the parking lot of the Hidden Marsh Sanctuary last night at about 3:30 in the morning, which is a weird place to be at that time. The police encountered when they recovered a pistol from your vehicle. So this is a felony and I need to get the case on track, but I also need to set your bond. So I'm going to show you plead not guilty. I'm going to set a pre-exam conference for June 10th at 8:30. Yes, and a preliminary examination if needed for June 17th at 1. Now, as far as I could tell, I didn't see that you had any criminal history. Are you on probation, parole, or bond anywhere?
No, I am not.
Have you been convicted of anything else?
No, sir. No, I have not.
Do you have a valid driver's license?
Permit?
Do you have a valid driver's license?
I have a permit, and there was a person in the vehicle who had a valid driver's license.
Yeah, there was another adult in the car, so I guess. All right. Are you employed?
Yes, sir.
Where's that?
I work at Walmart Care Center.
You work at Walmart, did you say?
Yeah, in the auto care center.
Okay. How long you been there?
I've been there since the beginning of this year because I was working at a factory.
All right. You live on Broadway Street?
Yes, sir.
Who do you live with?
My mom.
What's her name?
Her name's Teresa.
All right. So are you missing work right now?
No, but I will be if I'm still here Friday.
All right. Do you take any medication?
Yes, I'm supposed to. I've been trying to get into CMH, but they've been denying me. And I was subscribed to medications at one point when I was a kid, yes.
But not taking them. All right. Well, I really want to ask some questions like what were you guys doing there at 3:30 in the morning, but I'm not allowed to ask stuff like that at this kind of a hearing. I also want to know what you're doing with a loaded gun in your car, but the way I see this, you got no criminal history. There's no indication that any drugs or alcohol were involved. They didn't show that you've been drinking. The park closes at dusk.
Yeah, I did not know until the police officer notified me. We weren't allowed to be there until then.
Well, that isn't a place to go walking in the dark. But you live locally with your mother. You got no criminal record whatsoever. There was no assault or threatening behavior. You were essentially cooperative with the police. You were driving within your license restrictions, and you're employed. So that lends me to think that a PR bond would be appropriate. If I understand it, this gun was registered, but you don't have a CCW permit. I'm gonna set a PR bond at $2,500. There are certain conditions of that bond. No drugs and no alcohol. Curfew of what time you get out of work?
I get out of work at around 8 to 9 o'clock, depending on how busy we are, but usually it's 8.
I'm gonna do 11 p.m. curfew. Nothing good happens at 3:30 in the morning to 5 a.m. No weapons. Must not possess any firearms or dangerous weapons or reside where they are present. You don't have a CCW permit, so I don't have you relinquish it, but they have your gun. No assaultive or threatening behavior. Now, you can't use drugs or alcohol while you're on this bond, but I'd like you to try to make appointment with CMH. Yes, sir?
So I will notify you that with marijuana being legal, when I was at my house a long time ago, it would still be in, it would still be in my system. So how would that work? Because I know
All right,
last at least.
don't worry about it. Marijuana is legal for 26-year-olds to use, but while you're on this bond, you can't use it anymore.
Oh, okay.
So,
I was just wondering.
no, you're allowed to smoke it if you're an adult or use it in other circumstances. I think there's more to the picture here. I think there's some mental health issues here that I'd like to know more about. We're gonna get an attorney and explore some of that. I'd like you to try to make an appointment with CMH. But we'll explore that as we go further with this. Now, let me repeat, this is a felony. It's punishable by up to 5 years in prison and a fine of up to $2,500. You don't want to go over to prison for 5 years, and it's not very likely that you will. But we have this phenomenon where we have young men carrying loaded firearms around in their trucks. Makes me uncomfortable. Within the last 6 weeks, we've had 4 cases where they took the guns out and played Grand Theft Auto, blamming away at each other. So we got people shooting at each other. In fact, shooting. A couple people are actually shot. So we'll see. So I'm going to get you a lawyer. No drugs, no alcohol, no firearms. You have a curfew. You're going to be in by 11 o'clock at night. And I'd like you to make an appointment with community mental health. Anyway, we will address this further on June 10th. Now, you got a couple things going for you. You got a place to live. You're with your mother. You work very close to where you live, and you got a job. You got no criminal history. So don't do any more dumb stuff before we sort this out. But your bond is
Get a hold of them.
All right. So, yeah, back in the old days, we used to remember other people's phone number. I can barely remember my own phone number, but they're all on your cell phone. I don't see any reason why they need to seize your cell phone.
Well, I tried to call them and it didn't go through because I called one of my sisters earlier before I got to talk with you to notify them I was here. And they did not answer because, in fact, it was had to be paid for and there was no payment on the phone call.
Hopefully they'll give you your phone back and you can call somebody to come pick you up. Anyway, your next visit here is June 10th at 8:30. We're going to give you paperwork with your lawyer's name and number on it. I want you to call your lawyer and discuss this with them prior to your next court date. And I want you to see if you can actually get an appointment with CMH. And you can tell them the judge told you to go check in with them. All right, Mr. Wire, do you have any questions?
Yes, I have one last question. Since you said I have to be in at 11 a.m., is it available
11
that I
p.m.
also? Oh, yeah,
11
yeah, okay, sorry, 11 p.m. Yeah. Would it be possible, because I have 2 sisters that also live in Three Rivers that I stay with sometimes? Would it be possible if I'm allowed to stay with them too? I do know Sergeant Starks does know both of them. So if
you can, as long as you show up for court and you get your mail at that address, you can stay with your sisters. Now, it doesn't mean you got to stay in the house. You can be outside.
Well, I know. I just know that you're notifying me that I have to, by 11 p.m., be at a property that is safe for me, which is picked up my house. Or that's why I was asking if, like, my grandma
or your sister's house or a friend's house. I just don't want you out and about late at night.
All right. Okay. Yeah, that's all I was wondering is about that, because I've never had to do this.
Hopefully you'll get out. I'm going to give the paperwork to the clerk. She'll process it and you can get out before 5 o'clock. All right. Good luck.
We are on the record in 2024 TR 2964, State of Kansas versus Andravadon Patel. Jared Regier for the state. The defendant appears in person and pro se. We are set for bench trial. The state has charged that the defendant was driving without insurance or proof of insurance on November 9th of 2024 in Butler County. The defendant denies that allegation and apparently says he did have insurance at that date and time. So are we still ready to proceed, Mr. Regier?
There are 1 or 2 other housekeeping matters, Your Honor, but beyond that, the state is prepared to proceed.
Mr. Patel, are you ready to proceed with your trial?
Yes, ma'am.
And you still maintain that you did have liability insurance, correct?
I did.
All right. Now, what are these housekeeping matters, Counselor?
Your Honor, previously, before the last hearing, the state did file an amended motion for a post-arraignment endorsement. Based off of my notes from the April 16th hearing presided over by Judge Hutchinson, that amended motion for endorsement was granted. The notice of hearing attached to the same does set that motion for hearing on April 16th, 2025. Shortly thereafter, on April 7th of 2025, a motion for continuance was filed with the court, setting the matter over from April 16th, 2025 to May 28th, 2025. It would appear that the paragraph 1 of the motion for continuance does address both the bench trial and the motion for endorsement. So I'm not sure if the court feels it necessary to re-grant the amended motion for endorsement, but that is the state's request at this time, for purposes of the record, if for no other reason.
The endorsement is maintained. He's been endorsed. He or she has been endorsed and will continue to be approved as a witness in this case. So please proceed.
Thank you, Your Honor. The state is prepared to proceed to trial, Your Honor, and would waive opening statements at this time.
All right. Please call your first witness.
Thank you, Your Honor. The state calls Trooper Buck Herbert to the stand.
Please raise your right hand, sir. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
Thank you. Please proceed.
Would you please state your name for the record?
Trooper Buck Herbert
Where are you employed?
with the Kansas Highway Patrol.
And what is your professional title with the Kansas Highway Patrol?
I am a state trooper.
Approximately how long have you worked in law enforcement?
Approximately 7 years.
Okay. And approximately how much of those 7 years was spent with the Kansas Highway Patrol?
Since 2020.
Okay. So approximately 5 years with Kansas Highway Patrol specifically?
Correct.
Okay. Were you on active duty in your professional capacity on November 9th, 2024 at approximately 9:13 p.m.?
Yes.
At that time, where were you at?
I was traveling eastbound on K254 highway.
Okay. Do you recall what mile marker you were at approximately?
Approximately milepost 14.
Is that in Butler County?
Yes.
Okay. And when you were, say, traveling eastbound, were you in a vehicle of some kind?
Yes, I was on a marked patrol car.
Okay. Could you please describe the surroundings of the area as you recall them at the time?
It's a rural highway. It's a divided 4-lane highway.
Okay. So when you say divided 4-lane highway, would you consider K254 at this location to be a multi-lane highway?
Yes.
Okay. How many lanes, if you recall?
2 in each direction.
Okay. And what are these 2 directions that you're referring to?
Eastbound and westbound.
Okay. At this location, are the eastbound and westbound lanes of K254 separated by any open areas or landmarks?
It's separated by a grass median.
Okay. At this location, is K254 open to public use?
Yes.
Okay. And would you describe K254 at this location as more curving, or is it more straight?
There are straight areas and curved areas.
Okay. Do you recall this area specifically?
I don't recall.
Okay. Trooper, are you familiar with KSA 43104?
Yes.
And what does that require drivers in Kansas to present to law enforcement upon demand?
Proof of liability insurance.
And is that an optional request to the best of your knowledge?
No, it is not.
Okay. So is it your testimony today that the mandate about drivers in Kansas providing liability insurance is mandatory to all drivers?
Correct.
Okay. Your Honor, at this time, I respectfully request the court take judicial notice of KSA 43104.
Note taken.
Trooper, do you consider yourself capable of identifying traffic violations when you see them?
Yes.
Besides your approximately 7 years of experience that you had referred to, do you have any other past experiences or special training that enables you to identify traffic violations on site?
No, just my training.
Okay. Do you have any continuing education requirements that you're expected to meet in your capacity as a law enforcement officer?
Yes.
Could you please describe these continuing education requirements for the court?
40 hours annually of additional training.
Okay. And are you current on your continuing education requirements at this time?
Yes.
On November 9th, 2024, at approximately 9:13 p.m., did you personally see any acts that you consider traffic violations?
Yes.
What did you see?
I had a minivan pass me. I was traveling in the right lane. He was traveling in the left lane and came up behind me and passed with his bright lights on.
Okay. Now, how did you observe this minivan if it was 9:13 p.m. in November?
Coming up behind me in the mirrors.
Okay. And is it your testimony that when you observed this minivan, I think you said its bright lights were activated?
Correct.
Okay. And where are these bright lights? Where were these bright lights located on this minivan?
To the front.
Okay. And were your patrol lights activated on your vehicle at the time that this occurred?
My driving lights were, my emergency lights were not.
Okay. So your driving lights were activated at the time?
Correct.
Okay. And these driving lights, where are they located on your patrol vehicle?
Tail lights to the rear and headlights to the front.
Okay. Do you recall the model, the make and year of this minivan that you observed?
It was a Chrysler Town and Country Pacifica, and it was a 2017.
Okay. And do you recall the color of this particular Chrysler?
I believe it was maroon.
Okay. Did you ever conduct a traffic stop on this Chrysler?
Yes.
Where did this traffic stop take place?
Shortly after I saw the violation. I don't recall exactly what milepost it was at.
Okay. When you observed this violation, to the best of your knowledge, was the Chrysler still in Butler County?
Yes.
Okay. Approximately how far from the county line were you at the time, if you recall?
I'm unsure about that. It was well within the county.
Okay. Once you conducted the stop, did you personally speak to the driver of the Chrysler?
Yes.
Do you see the driver of the Chrysler present in the Zoom conference?
Yes.
Could you please point the driver out and give a brief description for the court?
He's on the video for court security 3. It looks like a white background, some black object in the top left. He's got gray hair on the sides and bald on top, wearing a black shirt.
Your Honor, let the record reflect that the witness has identified the defendant.
It shall so reflect.
Trooper, did the defendant ever provide you with any official identification?
Driver's license.
Okay. And do you recall what state this driver's license was out of?
Kansas.
Okay. Did you ever ask the defendant whether they had proof of insurance on the Chrysler?
Yes.
How many times, if you recall?
I don't recall.
Okay. Did the defendant ever provide you with proof of insurance on the Chrysler during the stop?
No, he never provided me a proof of insurance on the stop. I believe he said that it was on his desk or his table at home.
Okay. Did the defendant ever provide you with proof of insurance on the Chrysler at any time after the stop?
Not to my recollection, no.
Okay. Did you ever write the defendant a citation for a violation of KSA 43104?
Yes.
Okay. Barring any redirect, no further questions, Your Honor.
All right, Mr. Patel, you can ask questions of the officer based on his testimony. It is not your chance yet to testify as to what you have to say, but if you have questions and only questions about his testimony, you can ask Trooper Herber at this time. Do you have questions?
I really don't have any questions, but
Well-
yeah, but I had the proof of insurance.
All right, we'll give you a chance to present that. But if you don't have any questions of the trooper, the state will move to its next witness.
Thank you, Your Honor. If I may proceed.
Please do.
Your Honor, the state calls Gina Panatex to the stand.
Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Very well. Please proceed, Mr. Regier.
Would you please state your name for the record?
Gina Panatex,
And where are you employed?
State Farm Insurance,
Okay. And in your capacity with State Farm Insurance, what is your professional title?
Underwriting Team Manager.
Okay. Are you a records custodian for State Farm Mutual Automobile Insurance Company?
Yes.
Okay. And how long have you worked as a records custodian for State Farm Mutual Automobile Insurance Company?
I've been with the company 36 years, so about 26 years in the leadership capacity.
Okay. And are you familiar with the records of State Farm Mutual Automobile Insurance Company in your ordinary course of business?
Yes.
Okay. Your Honor, at this time, I respectfully request leave of the court to share my screen.
Leave is granted.
Thank you, Your Honor. Ms. Panatex, do you see the document on the screen?
Yes, I do.
Do you know what kind of document this is?
Yes, this is to certify that the request that they asked was to verify that the coverage was enforced at that time.
Okay.
Yes.
And are you familiar with these types of documents in your regular course of business?
Yes.
Okay. What is the title of this document?
Certified policy record.
Okay. Do you see a stamp for State Farm Mutual Automobile Insurance Company on this page?
At the top of the letterhead.
Okay. And when you say letterhood, is this do you consider this type of document an ordinary business record?
Yes.
Okay. Scrolling down a little bit, do you see a signature on this page?
Yes.
Okay. Do you see the name and the professional title of the signer of this document?
Yes.
Okay. What is the name and professional title of the signer of this document?
Underwriting Team Manager.
Okay. And the name?
Gina Panatex.
Okay. Is that your name and professional title?
Yes.
And is that your signature?
Yes.
Your Honor, at this time, the state moves to admit the defendant State Farm Mutual Automobile Insurance Company certified policy record as State's Exhibit 1.
Any objection to that? Hearing none, State's Exhibit 1 will be admitted.
Ms. Panatex, do you see a date at the bottom of your signature line on this document?
Yes.
What is that date?
April 9th, 2025.
Okay. And this April 9th, 2025 date, is that before or after November 9th, 2024?
After.
Okay. Scrolling up slightly. Ms. Panatex, does this document identify the policy number of any State Farm Mutual Automobile Insurance policy?
Yes.
Okay. What is this policy number as indicated on the document? Does this document identify the full name of any State Farm Mutual Automobile Insurance policyholder?
Yes.
Okay. And what is that policyholder's name?
Indravatan Patel.
Okay. To the best of your knowledge, is your insurance agency holders of any other insurance policies involving this individual?
I am not aware of that. I don't have record of that.
Okay. Just a few more questions, Ms. Panatex. Do you see the paragraph beginning with the phrase "the policy"?
Let's see, say that again. I'm looking at.
Ms. Panatex, on this document, do you see the paragraph beginning with the phrase "the policy"?
I'm looking for that. Okay, yes, there it is. The policy
Okay.
was canceled.
Would you please read this paragraph for the court?
Yes, this policy was canceled effective September 1st, 2024.
Okay. And this September 1st, 2024 cancellation date, is that before or after November 9, 2024?
Before.
Okay. Ms. Panatex, is it your testimony today that that this particular insurance policy, as evidenced by the certified policy record, was canceled before the November 9, 2024 date and was confirmed by you after the November 9th, 2024 date?
Correct.
Barter and Riedrich, no further questions, Your Honor.
Thank you. Now, Mr. Patel, if you have questions of this witness about her testimony, you can ask them at this time.
Yes, Your Honor, when the renewal came,
Objection, Your Honor, testifying on cross.
You'll get a chance to testify later, sir. This is if you have any questions of this witness, questions that she can answer for you.
oh, okay. Well, I was hoping that the agent was going to be in the court.
Well,
instead,
you
but
could have.
She's not here.
Did you subpoena her?
No.
Well, then she probably wouldn't know to be here. But this is an official records custodian of your insurance agent's company. If you have any questions for her.
Well, as soon as I got the notice from State Farm.
Objection, Your Honor, testifying on cross.
You can ask her about the notice, but don't tell her what you did unless it's to ask her if you called or if you did what you said. You can ask her questions, but you're not to testify yet. Do you understand? Do I maybe need to explain a little bit the difference?
Yes, please.
All right. A question is you can ask her what she did, or if she knows what you did, but you can't tell her, because that's a statement like you would make when it's your turn to testify. Like Mr. Regier was saying, do you see that? What does it say? What is this document? Those would be the kind of questions that he asked. And then if you want to follow up with questions, you can do that.
Yeah, that's correct. Correct statement from her.
All right. You don't have any questions from her?
No. All
right. Then I don't really want to excuse you yet, Ms. Panatex. You may come up later in this case.
Okay.
So if you could stay just a little longer.
I will.
Thank you. Mr. Regier, any further evidence?
Your Honor, as a preliminary matter, does the court wish the state to stop sharing its screen at this time?
That would be, well, yes.
Thank you, Your Honor. At this time, the state has no further witnesses.
All right, state rests.
The state does so rest, Your Honor.
All right, Mr. Patel, the state says they've presented all the evidence they're going to, and now if you want to present any evidence you can, now would be a time. If you want to make statements, you can do that. But I do have to give you an oath. You don't have to make statements if you don't want to, but you can if you want, or you can call other witnesses if you want.
Well, I don't have any witnesses.
All right. Do you want to testify on your own behalf? Again, you don't have to. Okay. Then please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Very well. Thank you, sir. Please proceed to tell me your name.
I'm Indravardhan C. Patel. I'm from 1111 East Central Avenue in El Dorado. I've lived there for 47 years.
All right, and you're the defendant charged with driving without liability insurance in this case?
Yes,
All right, so you appear to agree that you were driving on November 9th of 2024. Is that true?
that's correct.
And were you at the location the officer said you were?
Yes.
Okay, but you have entered a plea that you're not guilty. You want to tell me why you're not guilty? Or
I,
anything you want me to say? It's whatever you want me to hear, anything you want to say.
yes, I had the copy of the insurance with me, and initially I talked to my agent, Valerie Bean, and I told her that how come so insurance went so high up? It was nearly $134 extra from the previous year or previous 6 months. So I was not very happy about that, and I consulted with her over the phone, and she said she'll
Objection,
look
Your
into.
Honor. Hearsay.
We can't get into what she said unless she's here today. You can say what you told her, but not what she said.
I'm telling you what I told her over the phone.
Okay, just stop,
And
but don't tell me what she said.
okay. And no, the thing is, she, on over the phone, she says, I'll look into it.
Objection, Your Honor. Hearsay.
All right, so she told you something over the phone, and then what did you do?
And she never called me back on this
Okay,
issue. Okay.
now when did you have that call? Was that
And
before or after November 9th of 24?
before.
Okay, go ahead.
And then when after all this happened, the stop and the officer gave me a ticket. I went again to her office personally, into her office, and tried to talk to her about renewal and new rate and all that. But she was busy that night, that evening around, I think around 3:30 or so. She was being busy. So she told me that, look, I am
Objection,
not.
Your Honor. Hearsay.
Hearsay, yeah, it is a hearsay, but I'm telling you what experience I had with her.
She was not able to look into what you wanted that night. So did you leave?
No, listen, Judge, that she told me that, look, I'm
Your
very
Honor.
busy, whatever she's
Your
doing.
Honor.
I'm going to allow it to a point, Mr. Regier. Go ahead, sir.
Your Honor, the state would lodge a continuing objection to hearsay on the record at this time.
I will so note.
Thank you, Your Honor.
Let him go a little further.
Okay, and then because she was busy, she couldn't do anything that evening or that afternoon. And she told me she was going to call me back next day. I said, okay, then I'll wait for her call, and she might do something about the insurance, Like, and I've been with State Farm for a long time.
Hang on, sir.
Okay.
Wait a minute. So this time you're talking to her, was that after you got the ticket?
That's correct.
Okay. And you
That's
went in there to do what?
And
What was your reason for going in there?
going to either correct the amount I was supposed to pay, and I was willing to renew the insurance and all that. And she told, because she was busy, she could not do anything that evening or that afternoon. And then she told me that, look, Mr. Patel, I'll call you tomorrow, or next day, and she never called me. So because she never called me, I waited for a couple of days. I thought she would maybe be busy or whatever. And I waited and waited, and she never called me. So I thought I better start looking for insurance elsewhere. And that's what happened. I started looking and I got about 5 places I went to with David Matthews, who does Progressive, and another company I went to is American National, and then I went to Jack Insurance Company.
Your Honor,
Finally,
objection, relevance.
finally, I found out.
Your Honor, the state is requesting
All
your
right,
ruling.
stop. Okay, stop. Okay. The issue for me to decide today, Mr. Patel, is whether you had valid active insurance at the time the officer stopped you on November 9th, 2024. Whether you went out and got insurance after the fact is what Mr. Regier just called not relevant. That doesn't help me, the decision. The
Yeah, but
decision
before
has to
Judge,
be November 9th.
but before that, I did call her, and she never called me back.
All right, so she did not call you back and you never did come to terms with what you should pay for your insurance? Is that what you're testifying to?
Yes,
Okay. And
it was $134 more than previous 6 months, which is very high for me. On one vehicle, I hardly drive, I hardly had any accidents or nothing, no claims, nothing. And she kept telling me that the insurance will be reduced the next time you come. But instead of reducing, it went up.
Okay.
By $134.
All right. But again, keep your focus on
And
whether or not
that was my objection to her. And I called her. I said, why you increase so much, you know? And she had no answer for it. And she says, okay, I'll look into it, and never call me back. What she looked into it. And then the second time I went was I personally went to her office and trying to defend my insurance rate, you know. But she didn't do. And then again, same time she was busy, and she told me that, look, I'm very busy right now. I can't do anything, and I'm going to call you next day. And she never called me next day, and never heard from her at all. Till today, she has not called me.
Was she with State Farm Insurance?
State Farm Insurance, yes. And I've been the insurance with her for a long time.
Okay.
On record. And not a single claim, and hardly drive the vehicle. You won't believe this, Judge. There is a 2017 vehicle. Is only that time it was about 18,000 miles. That's it.
Your Honor.
Since 2017.
Well, Mr.
I hardly drive. No claims,
Patel,
nothing.
I need to shut you down there a minute.
Okay.
Mr. Regier may have questions. Mr. Regier, any questions?
No questions, Your Honor, although if this court is going to continue to allow this line of questioning, the state would further allow a continuing objection on the grounds of relevance in this matter.
Sustained.
Thank you, Your Honor.
Mr. Patel, I'm hearing, was there anything else you wanted to offer, sir? Any evidence?
Yes. Can you imagine? I've been here in this city for 47 years. How can you believe that I can have no insurance? But this agent, Valerie Bean, she let me down by not renewing and not telling me. Okay, she keeps telling me I'll look into it, but no answer from her. I've been trying. 47 years. I've had so many vehicles for my daughters, for my wife, and everybody else. I've had insurance and never failed to pay.
All right, and I understand that, sir, and I'm going to have to stop you there because we do have some others that are set for trial too, and I've heard your position, and it sounds like we're just going over it again. So if you have no other evidence, Mr. Regier, have you any other evidence, any questions of him?
No further questions, Your Honor.
All right. So now I need everybody to stop talking and let me talk for a minute uninterrupted. What I have heard from the evidence is that you were stopped by Trooper Herber on the highway in Butler County, November 9th, 2024. When he asked for your liability insurance, you did not have it because your insurance agent had let you down. You'd been with her for many years. You'd always paid your insurance. You'd had a lot of coverage or policies because of your daughters, your wife, and yourself. But when you got your bill before November 9th, it seemed unusually high. You went into the insurance company and asked them, why are they raising it? The lady said she'd get back to you, and she didn't.
Exactly.
And so you never got around to paying your insurance. In other words, renewing it because you were waiting on her to get back with you and see if the amount was right or if it should be lowered or could be lowered. In the meantime, you're driving around without renewing your insurance, and thus you had no insurance. And when Trooper Herber asked for it, you couldn't produce it because you didn't have it. And then you went back to your insurance agent, and she still didn't give you a satisfactory answer. But by then, it was basically too late. You had been driving without insurance. So I do have to find you guilty beyond a reasonable doubt. And I'm going to order a $300 fine with 108 court costs. I'm going to order a 120-day suspended sentence. You won't have to serve that if you comply with a 6-month non-reporting probation. Now, you won't have to see a probation officer, but you have 2 things you have to do if you don't want your probation revoked and you don't want to serve your jail sentence. 1, you have to violate no laws for the next 6 months. Doesn't sound like that's going to be an issue. It sounds like you try very hard to follow the rules and the law. The other is you have to pay the 408. Do you need some time to pay that, Mr. Patel?
Well, why charge me, Judge?
Because the law says
That's,
if you drive without
yeah,
insurance,
it's
minimum fine of $300 and court costs of $108. I could go up to $600, but I'm not going to do that. So $408 you can
that's a lot.
appeal.
That's a
That's a lot.
lot. This
That's
is
what
worse than the insurance itself.
Well, that's what the Kansas legislature who made this law, that's what they set it at, and I have to follow it, and that's what Mr. Regier more times than not recommends. So that's why I'm thinking that would be a reasonable amount today, the minimum 300. I have to order the court costs of 108. I can give you, would 30 days be enough to get it paid? 60 days?
But Judge, I tried to call her and she never returned my
I know,
calls.
I know, but I
Uh,
wasn't the one driving the
while
car.
the insurance was still valid.
Okay, you do have up to 14 days to appeal my decision to the Court of Appeals. If you do, you have to put up a $408 cash bond when you file your appeal. If you don't appeal, you have 14 days to get this paid unless you tell me you need more time.
Yeah, of course, this is ridiculous, ma'am.
About 30
It's
days?
going to cost me, everything is going to so high. I was trying to avoid $134 extra charge. Now you're charging me $400. I mean,
All right, well, I'm not going to keep battling with you,
it's
sir. I will give you more time if you need more than 14 days. You need more than 14 days to pay?
I'll take as much time as you give me.
All right,
Because
I'll give you
I
30
don't know.
days.
I don't want to pay anything. I'm not supposed to
I know
pay.
you don't. And if you don't pay, your probation could be revoked and you could spend 120 days in the county jail. If you don't want to spend 120 days in the county jail, pay it and don't violate
Why?
any more laws.
A decent
And
man like me, why should I spend time in jail, ma'am?
you can talk to an attorney about that, just as I gave you the opportunity to hire an attorney before, sir. As they say, I don't make the laws. I'm just required to enforce them, and that's what I'm trying to do. Mr. Regier, in the interest of time, I did not ask you recommendations. I trust that what I
Can
did
you-
sentence
Can you
is,
please lower the cost?
I cannot
can you-
lower them anymore, but is there anything further, Mr. Regier, you have that you would like to make a record of?
Your Honor, besides thanking both Trooper Herber and Ms. Panatex for honoring their subpoenas, the state has nothing further in this matter.
And even this man who's talking to you, I called him on Thursday. He never returned my calls, just like the State Farm agent.
Well,
Two
he
times,
does-
even yesterday I
Fine,
called.
he's
He never returned my
prosecuting you.
calls.
Keep in mind, he's prosecuting you. He's not your attorney. So
No,
he's
but I have
probably
to
not
talk to
going
him.
to contact you. All right, I will let you go at
No.
this time. This case is in recess. Anyone here on this case alone is
Can you?
excused.
So can you give me what did you do? I didn't understand.
All right, listen to
but
what I
can you-
did. Quit talking and listen to what I did, and then
Yeah, please tell me one more time what I have to do.
talking.
This
I
is
keep-
not right.
Stop talking.
I've
All
done
right.
nothing wrong.
All right, if you want my answer, stop talking, otherwise I'm going to adjourn right now. The fine is the minimum allowed by law of $300. The court costs that I'm required to assess are $108. So you owe a total of $408. You have 30 days to pay that. You have a suspended 120-day sentence that you will not have to serve as long as you pay this and violate no laws for the next 6 months. If you want to appeal it, you have to do that on your own through the Kansas Court of Appeals. If you appeal, the clerk has to assess or charge a appeal bond, a supersedious bond of $408 cash when they accept your appeal. Mr. Regier will put all of that in a journal entry, and you can get a copy of that from the clerk of the district court in a few days. Now, if there's nothing further, we are in recess. You are excused to leave these proceedings, Mr. Patel, Ms. Panatex, and Trooper Herbert. Thank you all.
So how many days I have?
30 days to pay.
30 days.
Thank you,
Then-
Your Honor.
And
Mr. Regier.
before I let you all go, I just happened to think, Jenna, do I need to assess witness fees and do I need to assess witness fees as court costs too?
I'm not sure, Your Honor, but I can find out really quick if you want me to.
Sure.
Your Honor, I reached out to Michelle and she's saying that we do not need to assess those in the court cost.
All right. So everyone is excused from the case today. Thank you all. You may go.
How you doing?
All right. Okay, are we ready to proceed with Austin Nathan Nixon?
Yeah, that's awesome. I'm here. This shaggy looking dork.
24L001899, 25L000744, and 25L000902. And sir, that's your true and correct name. Your date of birth, May 12th of 1993.
Yeah.
And you still reside or receive mail at the 9016
Of course I do.
Whitman Avenue?
Yeah, I do.
Okay. And did you go through the constitutional rights that attach an arraignment with the attorney?
No. We just make stuff up as we go. I'm just kidding. We
I
don't.
can't, just a second, sir. Okay,
I'm
I
sorry.
need you to be quiet for just a moment while I hear from your attorney.
Okay.
Counsel,
I'm a judge today.
I need you to be quiet for a minute if we're gonna have this hearing, okay? All right, I'll hear from the attorney.
Yes, Mr. Nixon, do you remember the rights that I went over with you?
Yeah, I do.
Do you have any questions about those rights? Okay.
All right, I will turn it over to counsel for entry of plea.
Thank you, Your Honor. We'll acknowledge receipt of the complaint, waive further formal reading, ask the court to enter plea of not guilty to the charge. And it appears we do represent Mr. Nixon on the other matters, so I would ask to be direct appointed on this new matter.
All right, based on the record made, I will do a direct appointment to the public defender, waive a formal reading of the charges, and stipulation for purposes of setting conditions, counsel?
Yes, Your Honor.
Or maybe probable cause was already found, I'm not sure, let me see. Probable cause, nope. No, it was just reset. So I'll enter the stipulation. At this point, sir, I'm going to turn to the prosecutor. He's going to make his recommendations on your release, and then I'll allow your attorney to respond. City?
Your Honor, the city would request the court maintain the bail that was set on the cause number 2500744 regarding the arraignment. This was a matter for which the defendant broke a rear window in a vacant building owned by the Living Access Support Alliance. And in addition to the standard conditions of release, the city would be requesting to have no contact with any property owned by Living Access Support Alliance.
Okay, and I don't see that bail was set, so is the city, perhaps the docket just hasn't been entered, but I don't see, so just you're gonna have to articulate the amount that you were thinking was previously.
Your Honor, I thought bail was set on the violation of the protection order.
Looks like he was PR'd April 14th.
I thought I saw something that was $10,000. I may have misread the docket.
I'll look at I've looked at one of them. I'll look at the last one and see.
I trust your reading better than mine.
Let's see. I just show this up. This one was also set to track. Let me see.
I think I may have misread the docket on a different individual. Your Honor, the city would then be requesting bail in the amount of $3,000 cash or bond. The basis for that is that this is the defendant has significant warrant history. But as indicated, the city believes that bail is warranted, but will defer to the court as to the specific amount.
Okay, thank you. All right, I'll turn to defense.
Thank you, Your Honor. We would ask the court consider releasing Mr. Nixon on his promise to appear. I do note that the incident date for the newest charge was April 30th, and this was filed on May 12th. And looking at the protection order violation docket, it does appear that he was released and he did return to court on May 8th as well. And it looks like he was not able to return to court on May 27th because he was in custody in a different jail. So he is making an effort and he has been appearing out of custody. And given the nature of the charge, we would ask the court to consider releasing him on his promise to come back on all the matters.
Thank you.
All right, give me a moment to review. Well, the complication for the court is that I see that he's had some 30-day sanctions, 2 or 3 different warrants on the other pending matter. And so I have concerns about violations of conditions of release and the failures to appear previously on the review matter. As recent as this year, several failures to appear. So I do feel some bail is appropriate. I'll impose $1,000 on each case totaling $3,000 total. That's only $1,000, which the court considers pretty nominal for the amount of charges in a short period of time. On each of the 3 matters, I will set this case for hearing 1 week from today. And I'll set an out of custody pretrial as well. I've done a direct appointment. So sir, on your paperwork, you'll have your next court date, your conditions of release, as well as your attorney's contact information. I will order you to have no contact with the LASA buildings or any of their employees off Gravely there, as well as law-abiding behavior, only using your true and legal name and date of birth, updating your address if it changes, and appearance at all court dates. Any questions about your conditions of release, sir?
So will I be being released today?
If you post bail,
Okay, so and if I don't post bail, I'm staying here for a week?
we'll see you a week from today if you don't post bail, correct?
Okay, thank you.
Anything further from either of the parties?
No, Your Honor.
No,
Thank
Your
you.
Honor.
All right, I've signed that order, and I encourage you, sir, to reach out to your attorney, but he's already left. Okay.